We would like to continue with our discussion of corporate governance, especially directors. We have so far understood who a director is within the meaning of our company law, and we have noted that our lawmakers look at the function rather than the label or the description. So someone who has been appointed to administer the business is a director. And then we look at the concept of those who also hold themselves out or allow themselves to be held out, as in de facto director and then shadow director. And we look at the case of Commodore and then the food supply. And again, we also discuss the appointment of directors, how directors are appointed. And we noted that it depends very much on whether we are talking about first directors or subsequent directors. And we noted that the first directors are those who are selected at the very commencement of the company or during the incorporation. Their names are actually put down. And we also noted that after the first set of directors, all other directors, we treat them as what we call like the subsequent directors. And the appointment depends upon whether you are dealing with a private company or public company. For private company, we noted that at the first AGM, all the directors, if you like, will be deemed to have actually exhausted their mandate, and you have to elect a new set of directors, although they are eligible for re-election. Then we also noted that for public company, there's what we call the rotation principle, so that only 1/3 of the directors actually retire and then they are replaced. And we explained that to mean that in order to ensure institutional memory and avoid situation where you have like a complete set of people who do not remember anything about the company. And then we also look at the rules and the permutations regarding how the details of this 1/3 we arrive at it. And again, we also discuss qualification and disqualification of directors. And we noted that the law has made a presumption that every adult of sound mind, you are qualified to be a director, unless you fall within certain categories or situations which have been adumbrated in the law, including the fact that if you've ever been convicted of offense or fraud in relation to incorporation of a company, or if you have ever been a subject matter of a bankruptcy order and you have not been discharged by a court of competent jurisdiction, or if an order has been made by a court restraining you because you have been involved in some fraudulent dealings relating to a company. And for that matter, you are prevented from being appointed a director, as the case may be, then you are also disqualified. Then we noted that because we will not be able to actually ascertain all these facts, as part of the appointment process, those who have been appointed directors and then they're going to consent to the appointment in writing and all that, are also required to swear to statutory declaration regarding the matters that we have talked about in terms of their qualification. And Statutory declaration, as we noted, is a sworn statement, so that if it turns out that what you said, that you are qualified in the various ways that written in the law, and it turns out that it is not true, that is a very serious thing, because you have lied under oath, so to speak. So we look at that. And then again, we also noted that some companies may make provision for what they call share qualification. And then where it is a requirement that to be a director, you must have shares. Then if you did not have the requisite number of shares, upon being appointed a director, you have a period of up to 2 months within which to actually build up the number of the required shares, failing which you cease to be a director. And again, we also noted that it is permissible for a company which has a registered constitution to make additional provision insofar as they are not inconsistent with the requirements of the law, and provide some other qualification which a person who wants to be a director must actually meet. Yeah, so we noted that as well. And then again, we discussed the issue of a casual vacancy. And by casual vacancy, we said that we are referring to the situation where directorship, that is the office of a person as a director, has not really come to an end in terms of he having exhausted his term of office or mandate, but he ceases to be a director, such as he resigns, he dies, or he's even removed. All those things will be instances of casual vacancy. And we noted that, of course, the company, through ordinary resolution, may fill such a casual vacancy, or the directors may actually fill that. Except that when directors are filling casual vacancies, they are required to be mindful of the onerous responsibility which the law imposes on them in terms of the duty to be good faith, the duty of good faith, the duty to avoid conflict of interest, the duty to have the interests of the company as a whole, and also other stakeholders in the company into consideration when they are exercising the power to fill the casual vacancy. So these were things we discussed in our previous class when we met to discuss corporate governance in relation to directors. So tonight we want to continue our discussion. I would like to continue from removal of directors. And this is a very important, and for that matter, we need to address our minds to it very well. So first and foremost, we have to remember that the procedure for removing directors is what has been set out for us in section 176. And that procedure is that which must be followed anytime you think that a director should be removed from office, and not other backdoor route if I say other backdoor route, I'm referring to what happened in the case of Pinaman and Abrokwa. Let me put it there. Pinaman versus Abrokwa. Let me give you the citation. You know, you'll be discussing what we call the remedy against oppression under section 218 and all that. And what usually happens is that, you know, where people want a director removed, you have to invoke the specific procedure which has been actually provided in the law for removing directors and not any other. So look at Pinaman and Abrokwa 1991. Ghana Law Report. I don't know if you are seeing from the charts. To Ghana Law Report 284. Yeah, so Pinaman and Abrokwa to Ghana Law Report 284. And the court will actually emphasize that if you want to remove a director, you must actually follow the procedure which has been prescribed in the law. In this particular case, section 176. Of course, this is without prejudice to the power of the court to give appropriate remedy where a person is complaining that maybe the way and manner the affairs of the company are being run, they are being run in disregard of his interests as a shareholder. Yeah, so let's move on, but I would like you to read the case of Pinaman versus Abrokwa. And as I said, there is the authority for the proposition that where the law has prescribed a particular procedure for removal of directors, it is that procedure which must be resorted to, and not any other procedure. So in this particular case, what happened was that we had a situation where the directors and then the shareholders of a company called the AFC Limited were in court, and the directors and the majority shareholder, I mean, there was a complaint that the affairs of the company were being conducted in a manner which was oppressive to them and in disregard of their proper interests as well as members. They were actually accusing the majority shareholder, who also happened to be like a director. And for that matter, they invoked the predecessor provision of section 218 of Act 992, which also used to be section 218 of Act 179, and invited the court to grant relief, including removal of this director. And in relation to that, the Court of Appeal, speaking through Justice Lamte, had the following to say, and I quote, "One of the reliefs sought by the applicant was formulated as relief B as follows: an order that the current chairman of the board of directors of the company be removed from the board. The judge continues talking. The first observation I wish to make is that Act 179 specifically provided for the procedure and the mode for the removal of a director of a limited liability company under Section 185. Remember, Section 185 is the previous version of the current Section 176. The judge continues talking. Prima facie, to remove a director of a company from the office of a director, the procedure spelled out under Section 185 of Act 179 must be followed by the company. It seems to me that the applicant must satisfy the court that resort to Section 218 of Act 179 have become necessary as a final and last resort. In other words, the affidavits of the applicant must on the face of it show that the applicant resorted to Section 185 without avail and without success. That as a last resort, the almighty power of the court must of necessity be called in aid of the applicant. There was no evidence to show that the applicant had unsuccessfully attempted to remove the named director chairman pursuant to Section 185 of Act 179. That resort to Section 218 of Act 179 could be justified. The lower court, in my opinion, had no jurisdiction to hear and determine the relief sought under Head B of the reliefs. The complaint made under Head B is not one envisaged by Section 218 of Act 179, and should have been refused and dismissed in limine by the learned trial judge of court. So simply as we have indicated, Pinama versus Broker establishes the point that you must have recourse to Section 176, which is a dedicated procedure for removal of directors, failing which you may go to other places like Section 218, but you don't ignore the particular procedure and then just go after any other procedure. Otherwise, you be on the frolic of your own and you just be a busybody. Okay, so let's find out then, what is the procedure contemplated under Section 176 for removal of directors? First and foremost, if you look at the provision, it is a requirement that an ordinary resolution is passed for removal of directors or a director. And the emphasis is on ordinary resolution. And again, I want to bring to your attention that it is possible and in fact permissible for all the directors en bloc, that is all of them, wholesale, to be removed from office, so long as the company has followed the procedure and passed the ordinary resolution that they should be removed or a particular director should be removed. However, according to Section 176, before an ordinary resolution will be passed for removal of a director of a company or directors of a company, there must be a notice of intention to move the ordinary resolution for removal of the directors or the director or directors. And this notice should be given out not less than 35 days before the meeting. So if you think that a particular director should be removed, then the director is supposed to be given advance notice of at least 35 days before the meeting in which the resolution to remove him will be passed. So let us take that into account. And again, if we look at the 176(4), in particular, the company shall give the members notice of the resolution at the same time and in the same manner as the company gives notice of meeting, or if that is not practicable, shall give the members notice of the resolution in the same manner as notice of meeting are required to be given not less than 21 days before the meeting. Now, the difference between section 176, subsection 3, and section 176, subsection 4 is that in the so it is, usually 35 days is what is contemplated, but sometimes for practical challenges, practical reasons, that may not be feasible. And where that is not the case, then you are supposed to observe the minimum of 21 days, a notice. And 21 days is the usual notice for conveying a meeting, and that will have to be observed. Now, the purpose of giving the notice, the intended notice for the removal of the director is that it enables what we call the audio terram partem principle to be given meaning to, because the director will know ahead of time what are the charges or what are the allegations or grievances being advanced against him. And as 176.5 contemplate, the director who is to be removed will be given the notice, or will be given the information, let's put it that way, that he has the right to be heard on the resolution. And if you also want to send a written statement ahead of the meeting, so that it will be circulated to members who are going to attend the meeting, that is also permitted. So you see that there's some reasonable fairness actually incorporated in the law relating to removal of directors. Yeah, Sami, I noticed your hand was up, so let's hear you before we continue. Yeah, Sami.
Hello, sir.
Yeah.
Yeah, so when you were explaining the section 176 3, and with the help of 176 2, your voice wasn't too clear. So I want to see clarification. Per section 176 2, a notification is supposed to be given not less than 35 days, but then coming to 176.3, it says that if the notice, when the notice is given and then the meeting is held within the 35 days or less, it is properly given. It means that it is not out of place per section 176. Is that the case?
Yeah, and that is, yeah, but you have to read 176 as a whole, and also look at section 176. Oh, okay, they have an opinion. Just a second. Yeah. Yeah. So if you look at the 176 as a whole, you notice that usually when it comes to meetings, the notices are given supposed to be a period of at least 21 days. So where the intention to move the resolution is given to the company, but then a meeting is going to be held within 21 days, that will be considered as due compliance. So that is the import of the 176, 2, 3, and 4 read together. And that is why the 4 will say that the company shall give the members notice of the resolution at the same time in the same manner as the company gives notice of the meeting, or if that is not practicable, shall give the members notice of the resolution in the same manner as notice of meetings are required to be given, not less than 21 days before the meeting. So we are talking about two things here. Let's say, Mr. Sami, you want to remove Director K from office. You need to bring this to the attention of the company. So you need to send a notice of intention to move into the company. And ordinarily, that is supposed to be the 35 days minimum before a meeting is held for the resolution to be considered. Now, you have told the company, but then meeting has to be convened. And to convene a meeting, you need to send notice to those who are eligible to attend the meeting, the members. Now, we are saying that if, for example, we cannot have the luxury of 35 days, since the company was made aware that somebody would like a resolution to be moved for the removal of a director before the holding of that meeting and so on. If we are able to satisfy the 21 days notice, which is usually the period for convening meeting, in the case of letting the members know, that will suffice. Yeah, so that is the point. But you, the person who would like to bring it to the attention of the company that you want the resolution to be moved, you are supposed to bring this to the attention of the company at least 35 days. But then once the company is made aware, the other step is how to make the other members, like the members who are going to attend the meeting, should they also be given 35 days? And that is where we are told that if it is not practicable to give them such a long notice, it will suffice if we are able to bring it to the attention in the same way as they are giving the notice of a meeting, which is usually not less than 21 days. Sami, I don't know if it's clear for you now. Is Sami here? Sami is the president, isn't it? Oh. Okay, you have a two Sami, all right. Yeah, Sami.
Hello, sir. Yeah, the president.
Yes, president.
Yes, I've understood.
Okay. Yeah, so we were making the other point that once the company has been notified that a person is interested in getting ordinary resolution moved for removal of directors or a particular director, the company is obligated by section 176(5). It's obligated by section 176(5) to actually bring it to the attention of that particular director that someone has proposed this resolution And you also have the right to actually put statements together, reacting to the whatever allegations are being made against you. And you are discussing meetings with Mr. Stanley Shibua Jemfi, and I am sure that you have discussed the Schedule 8. Schedule 8 in relation to circulation of member circulars or statements. You know, when we're having like a meeting, when we're having a meeting, you can actually cause a statement to be circulated for attention of members. And you know that Schedule 8 of Act 992 has rules which govern that, including the fact that it's not supposed to exceed a certain length, I think 200 words and so on, and that it's not supposed to be defamatory. And then if the particular statement, for example, is not brought within the time required, then the company will not be obligated to circulate it at its own cost. And you, the person who is initiating it, may have to bear the requisite expenses of burden in circulating it and so on and so forth. So all those things in the Schedule 8, mutatis mutandis, or with necessary modification, are also applicable to statements which may be made in relation to the proposed resolution to remove the director. But of course, as indicated, if you look at section 176, it actually says that the company does not have obligation, right, to send or circulate any such statement if A, the statement is received by the company less than 7 days before the meeting, or B, the court, on an application by the company or any other person who claims to be aggrieved, so orders on being satisfied that the statement is unreasonably long, or 2, the rights conferred by this session are being abused to secure needless publicity for defamatory matter. And the court may order costs of the applicant to be paid in whole or in part by the director, although the director is not a party to the application. In other words, where a director who is going to be removed becomes aware of the fact that maybe some statements have been put together by the person who would like the director to be removed, and that statement oftentimes to try to explain why they want the director to move. But then you know how human beings are. A lot of unnecessary things may also be brought in so that you end up defaming someone and so on. And remember the law on defamation. If the statement contains defamatory material and the company has used its platform, right, its network to circulate it, distribute it to all those members who by law are entitled to attend such a meeting, during which the ordinary resolution will be moved for removal of the director. Then the company could be a defendant to a future defamation suit. Because remember publication. If someone has written something defamatory and then you publish it to third parties, it does not matter that you are not the one who authored it. Your publication of it would also make you amenable to what? Defamation. And that is why the company, for example, may go to court and say that the company is not obliged to actually publish a certain statement because of a suspected maybe defamation or some other scandal, which publication of it may cause. So, of course, where the court is satisfied that a good case is made, it can order that the company should not circulate the statement and so on, and vice versa. But the particular director who is to be removed has a salutary right, or his right to fairness is salutary. And Section 176, subsection 7 is quite clear about that. That quote, without limiting the rights of the director to be heard orally on the resolution, the director may, unless the court makes an order, also requires that the written statements by the director be read to the meeting. Yeah, so he too can put together a statement and say that, well, the statement that I have put together should not only be circulated, I also like it to be read during the meeting for attention of all those who will be present before they make up their mind on how to vote on the proposed resolution for his removal. Yeah, so if the resolution is successful, in the sense that if they get the majority of them, of course, being simple, being ordinary resolution, we need what they call a simple majority. So if they get majority to agree that the resolution should pass, then the particular director will actually be deemed to have been removed from office, and that will automatically occasion an instance of a casual vacancy. Occasion casual vacancy in the sense that the term of office of the director has not actually expired, but he has been removed. Mr. Dauda. Somewhere, Dauda, where's his son? Oh. No, there's a hand up. Yeah, Mr. Dauda, you can unmute yourself.
Yes, please, sir. My question is, if a director of a company becomes incompetent, maybe to perform his or her duties, does it mean that the director he automatically ceases to be a director, or the company has to take a step to remove him from the office?
If said that he becomes incompetent.
Yes, if a person becomes incompetent to be a director.
Incompetent
does it mean that
become disqualified? Is that it become disqualified? Is that what you mean?
Yes, maybe you may also even be appointed by later, or maybe you are incompetent in performing your duties and other things.
Okay, good. And that is where section 177, for example, becomes important. So we come to section 177 will tell us that an application may be brought to court to restrain fraudulent person or people who have been found to be guilty or convicted of fraud or certain offenses in relation to a company or some otherwise disqualified. Such a person will be removed from being a director. But all the time, you need a court order. Because if you just tell me that I am incompetent to be a director, I will not agree. So you need to go to court and then you show that, and I also come and react, then the court will decide, isn't it?
Okay.
Yeah, so that is that. Good. So if you look at section 176, subsection 9, it's creating an exception to all that we have discussed with respect to removal of a director. And this is what it says. That this section does not deprive a director who has a service agreement with the company of a right to A, compensation, to which the director may lawfully be entitled under that agreement on the termination of the directorship, or B, damages if removal from directorship constitutes a breach of the service agreement. Now, we are going to discuss what we call executive directors, right? And non-executive directors and all that. And please give me some few minutes. Okay. Yeah, so I was making the point that there are some directors who, in addition to being a boardroom director, so to speak, may also have service agreement with the company. If you say service agreement, that is to say that maybe the person is a managing director or he's some executive director. So he's also an employee of the company. And where he is removed as a director, and let's suppose that that has automatic or somehow automatic consequence for his employment, then if in the employment contract there is a provision in it which says that should his appointment be terminated unlawfully, he is supposed to be compensated, that will actually hold. Of course, you cannot prevent shareholders from deciding who should be their directors. But then this person is not just a director, he's also an employee. But his employment might have been structured in such a way that he must also have his directorship. So if shareholders can actually have any flimsy excuses and just use their numbers to vote and remove you from office, and you cannot do anything about it, but then your employment should be protected. And that is why Section 176 makes the point that even where you have been removed as a director in accordance with Section 176, you are right as employee under any service contract with the company will still be upheld. You can still pursue it, notwithstanding the removal. Now, we come back to the question which was asked by Dauda, that if a person has become incompetent and that person be a director, or a court will have to order that person. Now, as I indicated, the solution lies in section 177, and I'll quote it. So somebody should read 177 1 for us. Who's reading for us?
I'm reading. No.
Okay. All right.
That's 771. A, where a person is convicted, whether in the public or elsewhere, of I, an office involving fraud or dishonesty, II, an offense in connection with the promotion, formation or management of a body corporate. II, an offense involving insider dealing. Or IV, any other criminal offense which is not misdemeanor. Can I continue?
Yes, please.
That B, a person is in Dutch. A person is a judge. The person is a judge bankrupt, whether in the public or elsewhere. C, a person has been culpable of criminal offense, whether convicted or not, in relation to a body corporate, or of fraud or breach of duty in relation to a body corporate. D, it appears that a person is debarred authority from being a member of a recognized professional body as a result of this disciplinary inquiry. Or there is an ongoing investigation by a criminal investigation body or by the registrar or the equivalent in foreign jurisdiction regarding the matters in paragraph A to D. I continue.
Okay.
The court or each own motion or on the application of a person referred to in subsection 6 may order that that person shall not, without the leave of the court, be a director of or any way or in any way, whether directly or indirectly, be concerned or take part in the management of a company or act as auditor, receiver, or liquidator of a company for the period specified in the order. Without limiting subsection 1, a person is automatically disqualified for appointment as director or to act as a director of a company for a period of 5 years if that person has been convicted within the last 5 years of an offense involving fraud or dishonesty or relating to the promotion, formation, or running of company, has been a director or that B has been a director or senior executive of a company that has become insolvent within the last 5 years on account of or partly as a result of the culpable activities of that director, or has been disqualified to act as a company secretary, receiver, manager, or liquidator of a company. Where a person referred to in paragraph A of subsection 2 is subsequently subject to to a second conviction, that person shall be automatically disqualified for a period of 10 years. And B, third conviction, that person shall be permanently disqualified as a director or to act as a director. 4, an order under paragraph A of subsection 1 may be made by a court in the country before which the person is convicted. A person referred to in paragraph D of subsection 2 may, I can't read for that.
But you don't have the reading from my screen.
Pardon me.
I thought you had your law. You go ahead.
May apply to the court for reinstatement before the expiration of the 10 years automatic disqualification period imposed under section 3. Sir.
Yeah, all right. Thank you. Yeah.
Yes, sir.
Okay, thank you. Yeah, so section 177 is playing very important. Please put your mic off. That's why I muted everybody. Now, if you remember, when we were discussing appointment of a director, in terms of section 172, subsection 2, we came across the principle that a person who is going to be appointed the director has to actually make a statutory declaration and say that he has not been convicted, he's not been charged, these offenses which are repeated in 177A are also reflected in section 172, subsection 2. So if you are going to be appointed director, you make a statutory declaration. Then the question is, what role does section 177 play? Now, section 177 is doing a very important thing, and this is it. It has mentioned certain offenses. If you are convicted of those offenses, whether in Ghana or outside Ghana, you are not qualified to be a director. You cannot continue to be what? A director, even if you were once appointed a director. You have to restrain from being a director. And apart from those offenses, there are also certain malfeasance, certain wrongdoings. If you are also involved, you will also be restrained from being a director. But what we are seeing under 177 is that in some situations, the court can give, if you like, a permanent bar. You are permanently debarred or prevented from ever being a director of a corporate body. Or the court may impose a time period and say that within 5 years, within 10 years, you cannot be a director of any corporate body or entity in Ghana. So that is there. Then the question is, how will the court make these orders? And that is where we are told that in terms of section 177 says that either the court on its own motion, if you say the court on its own motion, someone will ask, but how can the court know and bring up this case and say that XYZ is not qualified or is restrained from being a director in terms of section 177? There may be a case, right? There may be any case relating to the company or anything before the court, and maybe you are involved, and the court mix orders and say that because you have been involved in this particular established wrongdoing in relation to this particular company or in relation to that, an order is made that you are not fit to be a director of any corporate body in Ghana for the next 20 years or for the next 10 years or whatever years. So that is a typical example of how the court on its own motion may actually make an order restraining a fraudulent person or a person so adjudged from managing a company in Ghana. Or if you come to CIS, so many applicants are listed. A member of a company, if you know that someone who is a director, right? A person will be appointed a director, and subsequently you get evidence that, oh, but this person has even been convicted of stealing or falsifying or maybe some serious wrongdoing in relation to a particular company. Or this person has even been adjudged bankrupt, and then the bankruptcy of that has not been discharged and all that. So he is not fit to be a director. Now you, as a member, if you have the evidence, you can go to court and bring that to the attention of the court. Or another officer of the company. So officer here include a director, another director or any other person like maybe the company secretary and all that. If he or she has the basis to be convinced that a person falls within any of the situations contemplated by section 177, and for that matter, he or she is not qualified to be a director, he can go to court and then the court will look into it. And not only that, if you look at the 177 says B, it makes a point that a person who can demonstrate an interest in the case, and that is very interesting. That is to say that you don't even need to be a member of the particular company in which the person is a director or an officer. Let's suppose that there was a case, right? Let's look at like the list. Let's suppose that there was a case in relation to insider dealing. And maybe someone has been involved in insider dealing. He has used his position as a director and so on to make certain transactions relating to shares of the company, which ordinarily he would not have made had it not been for the information that he had. That is an example of insider dealing. And for that matter, you think that that person, having been convicted and all that, is not fit to be a director. You can actually go to court and get that. Now, let me remind you again. Let's compare section 177(1)(a), right, with section 172. Let's go to section 172. I want to show you something. Look at the screen. Good. So if you go to section 172(2), right, we are told that you should make a statutory declaration saying that 5 years before incorporation of the company that you are going to be a director of, right? You've not been charged with or convicted of any, you've not been charged with or convicted of any of the offenses which are actually listed there. But then, if you come to section 177, right? Section 177 is talking about concrete evidence, hard facts. No, 172, because of uncertainty, we don't have the evidence as whether you've ever been charged, you've ever been convicted of any of those offenses. But under 177, there is evidence, right? Someone has got the evidence that you have actually been convicted, right? you'll be convicted of any of the offenses listed, either fraud, dishonesty, and so on, or you have been a director of a company which has become insolvent within the last 5 years. So section 177 is actually about hard facts. The person is armed with the evidence that this director is actually involved in this situation. And for that matter, the court should make an order restraining him, preventing him from continuing to be the director or from ever being appointed a director, as it were. Of course, the registrar of the company can also bring it, or the official trustee can also bring it. And then trustee in bankruptcy of the person concerned. Usually, if you are adjudged bankrupt, right? If a personal bankruptcy order is made in relation to you and all that, an official may be appointed, and that person is supposed to manage your affairs because you are deemed to be incapable of managing your affairs, and that is why you become bankrupt. So you have to be, if you like, look after like a child. So a trustee in bankruptcy is appointed, and that person can go to court and say that this particular person, in respect of whom I'm the trustee in bankruptcy, should be restrained from becoming a director of any other company and so on. Or even a liquidator of a body corporate. So let's say that if you've been appointed a liquidator of company A, and Mr. Musa is in company A, and you get to know that Mr. Musa has been appointed director of company Z. Because you were a liquidator of company A, which is under liquidation, you could go to court and tell the court that the court should restrain Mr. Musa from being a director of the new company, Company Z. Yeah, so these are the range of people who can bring application under 177 to get a person who has become subsequently disqualified, or a person in respect of whom evidence has been uncovered, right, regarding his disqualification to be removed from office as a director. You know, in terms of whether the person is competent or not competent, the evidence may not be readily available. So you might have been appointed a director even 2 years ago, and later on somebody comes up with evidence that you are even not qualified to have been appointed a director because you have been convicted or you are involved in any of the stated malfeasance, as it were. So that is how it is. But of course, where an application is brought under section 177, it is the law that the applicant must give at least 28 days written notice of intention to bring proceedings under section 177 to the person. So if you want to bring proceedings under 177 against me, for the court to say that I should not be made a director, the law says that I must give me at least 28 days written notice. And not only me, also to the registrar of what? Companies. Because don't forget that the registrar of companies has interest in everything related to body corporates, as it were. And when the application comes up, the registrar, which has got information on all companies, could be subpoenaed or could be called upon to come and give evidence, as it were, or the official trustee could also be called upon to come and give evidence. But of course, if you sometimes an order might have been made against you, okay, under section 177, restraining you from being a director or saying that you cannot be a director unless you have gone to court for the court to give you leave, to give you permission to act as a director. So where that is the case, then section 177, subsection 9 says that if you are a person in such a category, you need to also bring an application to court. But before you can bring an application to court for the court to give you leave to be a director, despite the fact that you have previously been restrained from being a director, you also need to give 28 days written notice of intention to go to court for the leave to the registrar and the registrar of companies and official trustee or any other person who may need to be called as a witness, as the case may be. So now I would like you to appreciate that section 177 is actually serving an important, if you like, a gatekeeping role or gatekeeping mechanism. 177 has been a great watchman in terms of who really qualifies to be appointed a director or who is not qualified to be appointed a director. You can allow all manner of people to come in, but then when others who fall within the categories in section 1776, they get the evidence that a person was not qualified to be a director and so on, they can always trigger the mechanism under 177 and bring an application to court for the court to order that a person should be restrained or should be removed from being a director, as the case may be. Now, the registrar of companies is required to publish orders which are made by the court in relation to section 177. So therefore, if a person has been restrained from being a director, that order, a summary of it should be published in a document called the company's bulletin. So the company's bulletin is a special type of a gazette just for company affairs. So it will have to be published there. In the same vein, if someone who had previously been restrained from being a director went to court for leave to act as a director and leave has been granted, that will also have to be notified or published in the company's bulletin. So see section 177, subsection 10. And of course, the registrar of companies is also mandated by section 17711 to keep a special register, a special book, right, in which orders made under section 177 restraining people from being directors or giving leave to those who have previously been restrained from being a director to act as a director, the registrar or the document is supposed to provide this information. And this is very important because a company which intends to appoint somebody as a director can even go and conduct a search, right, to find out whether the proposed director has ever been a subject matter of any restraining order by the court and so on and so forth. And even the general public can also apply for search. And that is what section 177, subsection 12 actually speaks to. Now, to ensure that what is contemplated in section 177 is not taken lightly, it's not taken as a joke, and it should be complied with. Section 177, subsection 13, has created a criminal offense in relation to non-compliance, and where you are found guilty for not complying with what is prescribed in 177, you could actually be fined, or you could actually be made to pay. You could actually be made to go to prison for a period of not less than 1 year, or not more than 2 years, or you can be made to pay fine and also go to prison. You know, the penalty unit, I think the rate is still 12 cedis, isn't it? Is one penalty unit 12 cedis? Hello?
Yes, sir. It is.
Yeah, but I think that it's too small. It needs to be raised so that those who are minded to commit offense will know that we are not joking. Because let's look at it. If you are sentenced to pay 100 penalty units, that is 100 times what? 12, isn't it? And 100 times 12 is what? 1,000, is it 1,200 or 120? 1,200, isn't it?
Yes, 1,200.
Good. So
That is true,
1,200.
1,200.
Yeah, 1,200 is not biting enough. You know, a fine should affect your pocket so that you sweat, and that will be the punishment. I'm looking forward to maybe the penalty units probably being raised to 20 cedis, okay? So that if it's 20 cedis, it's still small, but at least it's more biting than the current 12 cedis. And that will be enough disincentive for committing crime. Yeah, so section 17714 has actually explained two new concepts which are being introduced for the first time, although when we are discussing directors, duties of directors, we'll meet it again. So 17714 explain what it means by insider dealing, and insider dealing according to section 17714 means buying or selling securities in a company by a person who have access to non-public information about the company, right? In other words, you have shares or some other securities like debentures and so on, and in a particular company, and you decide to sell it. And why are you selling it? Or you decide to look for more and buy. Why? Because you have access to a certain non-public information which is not known to members of the public. But you know it because of your position as an insider. So maybe you are aware that maybe the company has made so much profit, or maybe the next year the profit is going to be huge. And because the register has not closed, if you buy shares, you will be entitled to dividends when they are declared. Then you go and take plenty money from somewhere, you go and buy more shares in that company. And you are the only person buying a lot of shares and nobody else, because you are acting on a non-public information and insider information you have that in few months, the company is going to post massive gargantua profits, meaning that more dividends is going to be paid, and you like to benefit from that. So here, you wouldn't have actually made those extraordinary purchases if not because of the information you have access to, which members of the public do not have access to, as it were. Of course, senior executive, according to section 177, subsection 14b, means an employee who acts in top hierarchy of the company, top hierarchy of the management of the company. So if you are an employee in that situation, you are treated as a senior executive. Any questions so far? Okay, so just before we go, let's take section 178. A duty which is also imposed on a director, okay? So we are still trying to answer the question the gentleman asked, Mr. Dowda. If you are a director and you know that you have become disqualified, you don't have to keep quiet and say that, well, I'm keeping it to myself until someone takes it up or until it becomes public knowledge. No, you have a duty to self-report that I have become disqualified, or due to certain developments, I cannot be a director again. Okay. Yeah, so let's take section 1781. Reader. Is the reader reading?
Hello.
Yes, go ahead.
Okay. Section 178. Duty of director to report disqualification. On becoming aware of the disqualification to act as director, the director concerned shall immediately report the disqualification to the board and the company secretary in writing. 2. A director who refuses to disclose or misreports the disqualification within 21 days of the disqualification commits an offense and is liable on summary conviction to a fine of not less than 500 penalty units and not more than 1,000 penalty units, or to a term of imprisonment of not less than 2 years and not more than 5 years, or both the fine and the imprisonment. 3. A vacancy created by the disqualification of a director under this section may be filled as a casual vacancy in accordance with section 172.
All right, good. Yeah, so just to reinforce what we'll be discussing, section 178 of Act 992 makes it mandatory that you, the director concerned, if you have information that you have been disqualified or become disqualified, then you have a period not exceeding 21 days to bring it to the attention of the company secretary or the board. You have to bring it to the attention of the board or the company secretary that, yes, you are no longer qualified, and then you can state it as it were. But where you keep it to yourself, then that is an offense. That is an offense. So all the things I will be discussing under section 177, right? If a judge, for example, is going to make an order under 177, and if there's evidence that a particular director was very much aware that they have become disqualified to act as a director and yet remain silent about it and continue to act as a director, that may lead the court to give a stiffer sanction, as it were, because the person is being dishonest. But of course, where you tell the court that, you tell the board and the company secretary that you become disqualified, is equivalent of you resigning, isn't it? It's similar to resignation. And for that matter, there will be a casual vacancy. Of course, we will not say that it's the same as resignation. I just said equivalent because resignation, you are not necessarily disqualified for your own personal reasons or whatever. You may want to resign, but where you are, leaving office as a director because of compliance with section 178, you've told them that you are disqualified. So that one is mandatory. It's not a choice, isn't it? Resignation usually has an element of volition, but here there's no element of volition because if you don't comply, you commit a criminal offense, as we have seen. And of course, where this vacancy has occurred by reason of you becoming disqualified and telling the board and then the company secretary. Since the casual vacancy, the board can fill it, or the members can also fill it, as we discussed casual vacancies already, as it were. Good. So next time we meet, and hopefully, I don't know, tomorrow you have a class. Otherwise, if you meet, yeah. So I'm proposing to have a early morning class with you on, okay, maybe Saturday. You can have in person with Mr. Jemfi, and then we can have additional class in the evening if you have the time online, because I'm still in Accra. So your prefect will work it out and then let me know. And you're also going to be giving some tasks. Your prefect has given me the class list, so you know what to do. A good night.
Sir,